Good afternoon. My name is Richard Linderman. I'm a partner with Ansel, Grimm & Aaron. I'll be moderating our session today. And the idea behind the session was really kind of war stories and horror stories from the community association industry. Everybody up here has well over a decade of experience. There's a lot of crazy things that happen. If you have been in a condominium or a HOA or a co-op for any time, you have your own stories, but there's a lot to be learned from these stories. So the idea is, I'm going to introduce everybody up here at the panel. Each person is going to start off with a story that they've prepared from their own experience. We will then talk about how some of the new laws, some of the changes in technology may have been able to help, and we have an open mic there. You can ask us questions. It's a smaller room, so we may not need the mic, but it's usually a little easier. So I'll start off with the introductions. On the end is Andrew Batshaw. He is an executive with First Service Residential Management. Right next to him is a good friend of mine and a board member from Community Hills Community in Newark, New Jersey, Kilolo Thomas. She's been on the board there for over 12 years. Sitting directly to my left is a partner of mine, Mark Wichnick. He is the head of our construction defect group at Ansel, Grimm & Aaron. And then myself, my name Richard. I'm with the Community Associations practice at Ansel, Grimm & Aaron, and our group's devoted to representing homeowners associations and co-ops in New Jersey and Pennsylvania. So we'll start off, and I think Andrew's got the first story for us.
Sure. So thank you everybody for coming out today. We understand it takes time out of your days, especially board members, to be able to attend, so it's great that you're here, and thank you, Rich, for the opportunity to sit on this panel. I've been in the industry involved with condominium management, originally as a developer and then with management companies for well over 20 years. And there's so many war stories that I have that we could talk about, be it a collection issue, resident disputes, from the management side, non-compete issues that are war stories for managers. But the one that came to mind to talk about here is a community. It's about a 30-plus-year-old community up here on the Gold Coast, residential high-rise building, very upscale community, about 314 units. A resident went missing for a period of time. The resident happened to be significantly in arrears and had a tendency to try to duck the management office, would sneak through the back door, come through the front door, try to find his way in, oftentimes wore disguises when he was going in and out of the building, just because he was so far in arrears and the community was really aggressively trying to collect those arrears. And he would disappear for a while and then reappear. And one evening, it happened to be the evening of the annual meeting at the community, a resident, for those of you that live in high-rises probably know where this is going, reported a foul odor in the hallway. And again, this happened to be the night of the annual meeting where everybody's gathered in the lobby for elections and to conduct the business of the association. So the manager went upstairs, using his sense of smell, tracked it to this gentleman's door. The manager and the superintendent made access into the unit. Once the door opened, they were overcome by the odor of decay. Turned out that the resident had what was deceased in the bathtub. There was still water in the tub, and then after investigation was conducted, it was determined that he was in the bathtub for about 3 weeks. The reason why that the smell didn't get out initially was because he was still in the water. And apparently it holds the odor down. But as the water started to drain through the tub, because no tubs are hermetically sealed, it was a very slow drain, the smell got out. So first part of the nightmare is how do you get this body out of the building when everybody's in the lobby trying to deal with that, and then the police presence pulling up in front of the building, plus ambulances, fire trucks showing up there because no police officers would go in the unit because of the smell. So trying to keep the residents gathered in the lobby and not migrating up towards the unit. You would think that would be the horror story. The horror story actually came after the fact. One, this resident, as I said, was significantly in arrears, so many of the board members felt that it wasn't the association's responsibility to take any action to disinfect the hallway, to do anything to control the odor, or to do any sort of biohazard cleanup, because the concern was that the association would never be able to collect from this person's estate, because the person was in arrears and they had done bank searches and knew that this person had no money. So you have 9 members on the board. 6 of those members want to do nothing, and the other 3 members say, well, it's our responsibility. Just because they don't have the money and it's not a common element, we still have to take action. The body was ultimately removed. Investigations were done. The association did some air scrubbing in the common hallways because this was a high-rise. And then about a couple of days after this happened, the local health department contacts the manager and tells him that the entire drain line for that unit from the first floor to the 30th floor has to be treated as a biohazard and cleaned so that there's no cross-contamination to any of the other units. The manager reaches out to the board, lets them know, and those 6 members of the board that do not want to do anything automatically say, no, don't do anything. And the other 3 members say, no, we got to do something. The manager, on his own, takes it under his authority based on the management contract, which says that in an emergency, the manager has the discretion to enter into contracts above a certain dollar amount to have things taken care of in the community, and relied on that as something that he could go back to with the board members that were not in agreement with the method, and contracted with a company for a little over $20,000 to do a biohazard cleaning of the line and do whatever they needed to do from the health department. When the invoice comes in, now the board doesn't want to pay it. So this is the difficulty. And when he reaches out to the town, to the health department, and says, you guys told me I have to do this, of course now the town's not going to put it in writing that it had to be done. So when we talk about the horror story of it, is what steps could have been taken ahead of time, what could have been communicated better, what could have been communicated more, could there have been an education provided? Ultimately, do you want to get into the ultimate yet, or are we going to go into that at the end? The ultimate end of it. You want to fire some questions?
I think we should do some questions.
Okay.
First, and then so the way that I had envisioned the setup is we would hear the story before we get to the ultimate conclusion. The panelists and the individuals here could bring up some ideas on what you would have done differently to deal with this. If you have some questions about it, I have an immediate question. And when you have a high-rise situation and you have a tenant that you know might be sneaking in, what do you do about checking to see if the unit's vacant? Or I know a situation that we have with Kilolo's community where you might have squatters in a unit or something. This seems like it would fall in that same umbrella. What could you have done about that ahead of time?
Sure. So one of the strategies that we use, and it's not at every building, at some point, even though it's the unit, not the common elements, something of the unit affects other units, be it leaks from above, side-to-side leaks. Oftentimes, buildings that have closed-loop heating or closed-loop systems for their heating and air conditioning, we use that as a reason to get into the units. The association's responsible for certain maintenance, and we use that as an in. We say that we're coming in to check the filters. The association certainly has the authority to do it, and when we're in there, oftentimes the super's peeking around. A lot of units in high-rises have residency limits. So we're looking to see, are there mattresses on the floor? Many high-rises have restrictions on washers and dryers in units. So we're opening closets. That's how we use the opportunity to get in to see if something's going on, particularly with Airbnb situations as well, with short-term leases. We certainly use routine maintenance as an opportunity to get into the unit to see what's going on in there.
Yes. Are there any questions before we get? Yes.
Yes, for the total amount of the cleanup, all told, what was the total dollar amount involved?
I believe it was about $22,000 was the total amount. So that could be disputed either way. It's too high, it's too low. Again, undetermined whether it was a reasonable cost. Ultimately, we were able to negotiate the cost down with the vendor, and were able to resolve the issue with the board. But it was to the point where it was about to go to litigation from the vendor, where the vendor was starting to put a mechanics lien on the building, which certainly nobody wants to get into that type of situation. And the insurance company, the association's carrier, denied the claim because it wasn't a common element issue. Vince?
Was the council called prior to the cleanup?
So council was engaged just about immediately as the cleanup started. And when we talk about where things could have gone differently, if council was engaged immediately, the association could have relied on the opinion of council, and essentially management could have relied on the opinion of council as well. So one of the things that we recommend for our managers and for our teams is that if there's ever a question, an association, a board, a management company should not be afraid to involve counsel to get an opinion. I'm not a lawyer. I only play one on TV. It's that type of thing. I know quite a bit, but I don't have a law degree, so I rely on the attorneys who really have a full understanding of the documents to provide that opinion to guide the board. Yes, ma'am.
How about your insurance? Would your insurance have covered any of the cleanup costs
For the management company or for the association?
for anyone?
Yeah, so the association's carrier denied the claim. They said because the problem didn't originate in a common element, that's why they denied the claim. We, of course, made the argument that it affected a common element because it was a common pipe. But the carrier denied it, and at some point, by the way, they're not with that carrier anymore, obviously. But at some point, that's where, and another thing to learn from this is when you're reviewing your insurance policies, when you're renewing, environmental coverage is very important. Having that environmental coverage and understanding what is covered by that environmental coverage. It's not always mold. Sometimes you need a crime scene cleanup in your community, and will that be covered because those types of things are expensive?
Yeah, one of the reasons why I asked that was we had a situation where there was a sewage backup,
Mm-hmm.
and when I called the insurance company, he said, absolutely, we'll take over
Yep.
from here. And he says, and any cost that the association absorbs
Mm-hmm.
to, what's the word that he used? Mitigate.
Yep.
Mitigate the circumstances would also be covered.
Sure. So when we look at insurance is certainly not an area where you want to cut corners. Insurance is there for a reason. The insurance market is healthy enough that you can be competitive. You don't have to go back to the same carrier. You can have your broker go out to different carriers or go out to multiple brokers. But insurance is so competitive and so active at this point that you can get a really, really good policy probably for less than you're paying currently.
So that's a good question on the insurance, because I was thinking that would have been something that should have been
You
covered
would
under
think.
normal. I have a question, and I don't know if this is going back a few years. Different property, it's a letter of the alphabet. There was a suicide. Do you
Yes.
know if the insurance cleaned up that high-rise building in Jersey City? They had a jumper off the top of the building. Now, the 6th floor of the building had a large deck that went around the whole building, so the jumper didn't make it to the ground floor. He landed right outside somebody's window while they're eating dinner on their patio.
Yeah.
So it was a mess, but I don't know if the insurance...
The cleanup was less than the deductible.
Okay, the cleanup
so the
was less.
association
Okay,
paid for it. Yeah.
like that.
Yes.
Going back to earlier, you said that you use maintenance as a reason to go into a
In
unit.
here.
Repeat the question.
Well, I'll repeat it after.
Okay. To go into a unit to see if they're, whatever the reason is. But if you find that they're in violation of an HOA rule or doing something illegal, then what? Then what do you do?
So what she asked was that we use maintenance as a reason to get into units, and if you find violations, what do you do? So every community is different. Their rules and regulations differ. As to your fine policy or your enforcement policy, what I would recommend is that if it's the first violation, there's a warning given. And again, this is all dependent on each individual community's policy, but you should give a warning. It should be written, so that way there's documentation. If it's a second offense, then I would recommend following your governing document and statute that whatever your fine policy is, that they're fined, they're offered ADR, and you go through the fine policy. Just because you were in there to look at something else, it's the association's duty and the board's fiduciary duty to enforce those rules and regulations. So you can't turn a blind eye to it. Just because you weren't in there looking for that specific thing, if you walk into a unit and there's 12 mattresses laid out in the living room, and there's a washer and dryer in an open closet, and they're not supposed to have washers and dryers, you have to enforce your rules and regulations. If not, the board is actually culpable.
Even if that wasn't your original intent for going into
Absolutely. So think about it as a police officer conducts a traffic stop for a person speeding, and when the person rolls down their window, they smell alcohol and marijuana. It's the police officer's duty to investigate the alcohol and marijuana smell in addition to the speeding violation. Association's the same type of thing.
Well, thank you, Andy.
Thank you.
I think it's a great story. It gave me nightmares. Oh, we'll do one more and then we'll move on. Yes.
Earlier you said that the resident was in arrears. How many months do you allow the resident to be in arrears before you take legal actions?
So this resident was in arrears, was in collections. There was a lien on the unit. The association was in the foreclosure process. I defer to attorneys on how to most expediently handle a collection issue. But for those of you that are board members, you know how long it takes to address a collection issue. And in a condo, you just can't evict people. So it was quite some time.
Just real quick for the board members.
Yeah.
What did the attorneys say, the board, even though those six said, we don't want to clean up, what was the attorney's opinion?
So the question was, what was the attorney's opinion? The attorney's opinion was that the association has an obligation to take action. So if you look at your governing documents, majority of the time it says that unit owners are responsible for X, and it defines what the unit is, what they're responsible for, and then it will likely say that if the unit owner doesn't take action within a certain period of time, the association has an obligation, not a right or an obligation or duty, to make the repair and bill the unit owner back. So that's where we talk about education. Understanding the documents is so important when you serve on a board.
And I think that would apply even if you know you're not going to get reimbursement.
You're going to
at
get
the
paid
end.
or not. Yep.
Doesn't make any difference. That doesn't change your duties.
Thank you.
Thank you.
Chloe?
Well, that was a tough act to follow. I don't have such an entertaining
Not all
story.
of them are about dead people.
Right.
Just to let everybody know.
Right. So, yes, I'm Kilolo Thomas. I am the president of the board at Community Hills Condominium Association, located in Newark, New Jersey. Just saying the word Newark, New Jersey, I'm sure that's kind of gives you an idea that the challenges that I've been facing since inception of me being on the board. Community Hills consists of 206 townhomes. Erected in 2000. I bought my unit in 2005, and probably by 2006 I sat on the board, and I've been on the board since. The challenge with Community Hills, and all condominium associations have the financial ups and downs, and folks not paying their maintenance fees and things like that. But from inception, we were fighting an uphill battle because the developer ran off with our transitional funds, so we didn't have the transitional funds. Community Hills was also designed to be a mixed income community where it gave folks with low incomes opportunity at home ownership. Okay, so coming in, I had with the opportunity, they got HUD funds, they got Hope One funds, and we're getting units for maybe $30,000 mortgages. And because they didn't understand what home ownership meant, and they still had a renter's mentality, these guys are losing their homes because for a $30,000 mortgage is like insane to me. Watching, families actually lose, value and property in their family and their legacy, just because they just weren't aware of how to manage home ownership, and then on top of that, manage maintenance fees. So we had that, and then again, when I started on the board, now we're part of the mortgage crisis happened. So that predatory lending was happening, where they were giving adjustable mortgages. So it was so many different, just negative aspects of trying to keep Community Hills afloat. So with partnerships, and one of the things I wanted to say, and I wanted to encourage any of the board members to take back, is that your partnerships with vendors are very important. That is the only reason why we were able to survive, because we had vendors, and we chose vendors who believed in the same vision as us, that we wanted Community Hills to survive. So, and Rich has been with us through, the lean times, and, stuck with us even when, we may have been a couple of months behind on invoices. He still stuck with us because he believed in the vision. So one of the things that we did, which was you know, something that I'm sure maybe other associations have done, but when we foreclosed on units, we actually started renting them out. So we would go and we would fix up the units, and then we would then rent them out. So we were doing that for a few years. And then now that the market in Newark is starting to pick up, right, all the folks that weren't interested in Newark are now coming. We used to have the sheriff sales. No one would be there for our units. You know, we were getting the units for $1. Now they're having bidding wars on getting those units, right? But do you think that those investors are coming in with the best interests of Community Hills? No, right? So they're coming and grabbing up all the units, right? And they're renting them out, right? And then they're putting in, of course, residents that are not in the same alignment of the vision for Community Hills. So I don't want to go too far because I was going to start talking about, because these are all strategies, and you know, and I know I'm supposed to be saying it as a horror story, but I'm trying to say more of a victory story, maybe.
We could use some positive stories.
Right. So. Right. So, like with the partnership and being strategic on trying to stay afloat. So now we had to move from rent receivership. There was no reason for us to keep, taking foreclosures because, that we're just going to have all these empty units to rent. So we decided that we would then now change our strategy, right? And so now when the lenders come in, the investors come in, right? We've already fixed all these units up. We've spent $10,000, $12,000. They want to come in and maybe just pay back 6 months maintenance fee, and then now they get to profit off of our investment. And so we have to fight and struggle, and Rich can attest to this, to actually get the investors to now reimburse us for all of those dollars. Okay. So that's one of the things. The second thing that we did is that we implemented a move in and move out resolution, meaning that if you were just coming in to rent out the units, every time you rent that unit, you have to pay us $500. Okay, and then on top of that, you have to pay us additional $1,000. And the reason why we do that is because we're trying to just keep the people who are coming in directly just to rent those properties out. We're trying to just make it as uncomfortable as possible. Secondly, we also do that because of the fact that makes you have to pick your tenant a little bit more wisely, because if you're just picking anybody, you're not going to want to keep paying that $500, that $1,000 to us. So it makes it very uncomfortable, and then so we can try and have some type of control, because you can't stop people from buying into your condominium association, but you can at least put some regulations to make it uncomfortable. And one of the other things that we did, because Andy did touch on Airbnbs, so we actually had that issue going on as well. Again, stay on top of it, make it very uncomfortable. We had a cease and desist letter sent directly to the owner to have that stopped immediately, because we're right there near Rutgers and UMDNJ. So guess who came to get the Airbnbs? We had the students coming in for parties, and there was one evening where they had about 80 people, and then we're talking about a little townhouse, right? And they didn't know, cause they didn't know what to do. When the cops came, they were just running all over the place, and everything.
There's a wrought iron fence around the community, so the cops pull up, all the kids come scattering out of the building, but they're all running into the fences. They have no idea.
They have
what
no
they're doing.
idea. So this is all going on. So thank goodness we had residents that had those, and these are the
Ring.
The doorbells that have the cameras, so we were able to get the footage. And so the one thing that we did do, and we were very, disappointed that we weren't able to stick with this one, is that we had actually passed a resolution. We actually amended our bylaws, actually, that you had to be a resident of Community Hills for 2 years to be eligible to sit on the board. Right, because again, you have all of these investors coming in, so guess what? Wouldn't it be great for them to sit on the board and they'll find out all about our units? So we were trying to, have a control around that as well. But unfortunately, we found out when we had our election this year that
It's the Radburn Amendment.
the Radburn. Okay, go ahead, Rich.
It was a strategy we'd put in place, but there was the recent Radburn Amendment, which changed that and basically nullified that ability to do that for us. But we were, for the last, 10 plus years, we've been looking at different strategies to address this. Some of them have worked, some of them not as well, but the board has been very open to trying new things, to try to keep the community as a homeowner residential community. And in general, I think they've done a great job, and they're definitely on the uptick in the last few years.
Absolutely. I mean, when I moved there, and during the mortgage crisis, our units were under 100,000. I bought my unit at 158. So, I was sitting on that board until that property value started going back up. But then now we have rentals of studios literally 1 block away from our association. They're going for $2,000. So again, that's making Community Hills look more and more attractive. And again, the vision that we had was to, like Rich said, to have a residential community for the community. And it's not some place that we want investors just to come in and just, just directly come in just to be, landlords. And we're really trying our best to hold on to our vision. So I think does anyone have questions? Oh, questions, okay.
With the Airbnb, are we allowed legally to put in our bylaws and make that cannot be done in our association? That's one thing. And the other thing is we're just trying now to make it, because I'm a realtor, I'm on my board, but I'm a realtor as well. And a lot of the communities that I sell in, they have it now where you cannot, if you buy a unit in there, you have to live in it 2 years before you can rent it out. This new law, has that changed what we are now trying to incorporate in
The first question was about
the Airbnb?
the Airbnb.
Yeah.
Now, most of the condominiums that I represent have a provision in there that limits short-term rental. Usually it's either 6 months or a year. You cannot have a lease. I believe Airbnb firmly falls within that prohibition. So that's usually what we use to enforce that provision.
So put that in, no short-term rentals like everybody else, 1 year.
Unless you have a very old association with very old governing documents, most of the ones that have been written in the last 30 years or so would have that short-term restriction.
Or a new developer that wrote in the documents 1 month rental, because they were trying to sell to investors.
Okay, and now what about the business of,
Remind me the second question again.
if you buy?
Oh, yes,
we're
yes.
trying to-
You have to hold on.
Investors are coming
Holding
in
on.
renting like crazy, and
If that requirement was in your master deed, if you've amended your master deed or was originally in your master deed, it's enforceable. If you've amended to put it in there, it's enforceable. I don't believe the Reverend has spoken to that at all. So that is a possibility. So you could put that, but it needs to be in your actual recorded governing documents. It's likely not enforceable if it's a rule or regulation that the board has passed. It needs to be in the chain of title recorded in your master deed or your bylaw.
so like we can't change that master deed?
No, you can.
Okay.
You would follow whatever provisions. Master deeds are usually 67%. Bylaws are usually, sometimes I see 51% as the lowest number to amend them.
So if I can, Kalilo, Newark truly is becoming a Renaissance city.
Yes.
It's been called that for many years, but when you look at Amazon possibly coming in, you said it perfectly, you have a Whole Foods now. And we're involved in a couple of projects in Newark, development projects, that Newark really is up and coming. The one thing that I will say for board members here, I know renters is quote-unquote the R word in the condominium industry. What we've found as a successful strategy is try to embrace the renters. If they feel that they're second-class citizens or they're being frowned upon by the community, they're less likely to treat your building as their home. So, and I understand it's a concern because of there's concerns with lending, the investor owners don't care, but the people that are living there still have to ride in the elevator with their neighbors. They still have to interact with the people next door to them. If you're able to embrace the renters, get them involved. A lot of communities say that you have to be a member of the association to serve on a committee. If you were to even create a renters group or a renters council, because renters have a certain mindset and look for certain things, the more you can embrace them and engage them and involve them in the community, the more likely they are to treat it as their home. And if they feel welcome, the more likely they are to buy it from their landlord. So when you think about it, some people, and you might want to even encourage your investors to do a lease to buy. contract or a rental agreement. And again, it's not every community, and not every renter is going to treat your community with respect. But if you can try to take the mindset of, as a board member, of not being against the renters, but really engaging them and embracing them as part of the community, you may, I'm not guaranteeing it, but you may see a change in the mindset of the renters and the way that you're treating your property.
Thanks. I think to touch upon that, the Community Hills Board, and I don't want to speak for Kilolo, it wasn't that they were targeting renters. It was that they were really the concern was the landlord. Was the investor?
Yeah,
The
that's
rent.
no problem.
Yeah. Once.
Landlords don't pay the maintenance,
Yeah.
but they're
Right.
getting the rent from the.
Well, so here's the thing. So
Once-
it's even easier for you, though. If the landlord's not paying the maintenance, just do a rent levy. Now you don't have to go through the collections
Doing that
process.
already.
Yeah, it's
very
easy.
hard to collect,
Yeah. You know, we knock on the door. Don't pay your maintenance, don't pay your rent to him anymore, you pay it to us.
Very hard.
But yeah,
They don't pay their fees, we are, we tow the car.
there you go.
Yeah.
We did
That's.
that, we put barrels.
Community Hills does.
Yeah, we
No
can't do
pay
that
here,
anymore.
no park here, see ya.
Yeah,
Now I hear we can't do that anymore, so.
Yeah.
I don't know.
yeah, rent levies are something that's very important. If you have a rental resolution for your community, and you have where you're required to get a copy of the lease, the association should have its own lease rider that every member has to use as part of their lease. And part of that lease rider should be giving the association the right to collect the rent from the tenant in the event that the member of the association does not pay their maintenance.
We actually just did that in one of the cases where.
Yeah, we do that
and
as well.
The guy owned, it was a sponsor who owned some 40% of the units.
Yeah.
So he was bankrupting the association by not paying, but still making $100,000
Right.
in rent. And the judge upheld our amendment to the documents and the lease rider and allowed us to collect directly from his renters.
We have a question here.
Oh, yes.
For Kikolo.
Kilolo.
The two, you said there were two fees you were charging the landlords. There was an initial 500 every time they changed, and then there was another 1,000.
Right,
What
so
was
okay, so when they move in and out, right? So now I don't have it in front of me.
That's okay.
Okay, so one of them is just the straight fee.
Right.
And then the other one is to cover costs as far as when they pull out all the bulk. We have 24-hour security, so when the trucks come in, we have security that actually escorts the trucks and monitors the activities that's going on while they're moving in and out. So the association should not be responsible for overseeing tenants of landlords. I mean, I think that's the other thing that we don't really think about is the fact that those tenants now become our management, our property manager's responsibility, technically, because some of the landlords might be in a different state. And so when they have issues, now they're calling the property manager instead of calling their landlord. So again, why should the association incur those type of expenses or those type of, because of rentals?
So the way that we framed it, and just to be clear, there has been some case law that's come down about just throwing out random fees with the idea of prohibiting renters. So it was designed in the sense that first the $500 fee covers the registration, the processing, the parking tags, all the incidentals, and whether or not 500 covers that or not, I think that's a reasonable fee. The $1,000 is essentially a security deposit, covers the security, it covers, and you can get a portion of the back at the end of it, I believe.
Yeah, I can't remember
Damage
which
to
one.
common elements and stuff.
It covers damaged common elements if your truck hits the curb and whatnot. What's been useful about that, though, is that fee goes on the account, and it's been helpful for these short-term rentals because every time we know you've rented and you haven't reported it, that fee goes on there, and it turns into essentially a fine. And that's how we've been able to enforce it, because if you had gone through the proper paperwork, you would have got that money back at the end of the day. But because you haven't gone through the proper, it goes on there as a fine, it's on your account, and we've been able to collect that and enforce that way. Yes.
That $500 fee, do you do the background checks on the individuals?
No.
No.
Has nothing
No.
to do with that.
Yeah, it doesn't.
I'm just asking the question.
It doesn't, and the reason is because in a condominium, the board does not have the authority to say you cannot rent to someone. There's been various cases, there's been attempts to have a minimal credit score to get in and whatnot. They're very hard. You run up against discrimination claims. We were defending one in Jersey City for that. Now, it's different.
Opposed to a co-op.
Again, opposed to a co-op is different. Co-ops will have different restrictions there and different requirements. But a condominium in New Jersey, you don't have the right to say yes or no to who's coming in.
But, well, let's go a little further. It's not a financial thing, but the person is on a list for criminal behavior or the like, or child, you can't do that.
No, probably not.
But
The question was, like with the Megan's Law registration and stopping there. That's an interesting question. I think that came up a few years ago. I think ultimately the courts came back and said that you couldn't restrict them. Now, the municipality may have restrictions if you're close to a school along those, but unless you fall within the umbrella, your community itself could not just say, put a blanket no, if you're on this list, you cannot get in. If you have a criminal background, you can't get in. So that's what we've seen in the past. Any other questions?
Did you have a question?
Oh.
Oh, yeah. Oh, okay.
All right, Mark.
Thanks, everybody, for coming. My name is Mark Wichnick. I've been doing condominium association related law for the last 15 years. And when Rich emailed about this, we must have talked about 4,000 stories. I mean, I think the key, what we want you guys to take away from today is that you're not alone in this sort of thing. Your association, I know statistically someone's is the craziest, but yours is not the craziest. This is not the first time we've heard these sort of things. I mean, we've dealt with things from unit owners harassing other unit owners, mentally ill owners harassing people at the pool and having to have them thrown out, sponsors who don't give up control. Most recently, and this came up for the first time that I can recall in a long time, 2 of our associations around the same time had their common areas sold at a tax sale.
Wow.
Our clubhouse in one of our associations got sold at a tax sale to some random guy.
Wow.
And so
the short story for that one is it's an HOA. The developer went bankrupt. So at some point the developer left, see you later, never showed up to another meeting. We could never find him again. We ultimately sued him on other things, but he himself never responded. The insurance company responded. We were able to recover money for them on another case, a defect case. But they never got the alleged turnover of all of the common areas. And our position was merely the filing of the master declaration transferred all of the common areas to the association. And the town never changed it, so it was only the developer. So when they continued to assess the clubhouse at a certain level, kept sending the developer bills, knowing full well they weren't going to respond because they were bankrupt and long since gone. They went into arrears, they sold it at a tax sale. So the first time we got notice of it was when one of the owners was talking to the tax assessor who he was friends with, and he said, there was some place in your association that got sold recently at a tax sale. And well, that's interesting. The developer owned a couple lots that you could still build on. We assumed it was that. And when we looked further into it, it turned out it was the clubhouse. So the clubhouse is no longer ours. And so we had to file a lawsuit to undo the entire foreclosure. They had never noticed us. They had never told the association. They never gave us any opportunity to fight it. And so we just recently participated.
What town that was?
It was in Hamilton Township, South Jersey, Hamilton Township, not Mercer County, Hamilton Township. So we went to a mediation yesterday on it, and so hopefully it will be amicably resolved before we have to spend a whole lot of money on legal fees. But
to give you a sense about that, the township at the mediation, which was one of the defendants, actually is paying the most of any of the parties on this because they've essentially agreed that it was their fault.
It was clear that it should have been our property. Who would want a clubhouse? And basically, as part of the mediation, we said, take it.
An investor.
Enjoy yourself. Yeah, an investor, but to do what to it? The zoning restrictions would preclude you from putting a Starbucks or anything in there. So right, you'd have people like living on the floor. It would be one of your flop houses, like with all the mattresses
12 mattresses on the floor
I mean,
in the great room.
if you wanted to sleep on the floor and play pool at the pool table all day, you're welcome to. But our board members were smart, and we basically told them you can have it, except we're not doing any more maintenance. We're not going to do anything to the property. Our roads are private, at least for now, until they're dedicated. So I'm not sure we're going to let you into the association if you want to do stuff. And, oh, by the way, there's 4 things that need to be fixed on it, so we'd like you to pay for those.
That was good.
And so if you want to keep it, you can have it. Our unit owners don't really use it. It's an over 55 community. They don't much care. You know, they use it periodically, and we use it for meetings, for our annual meeting and board meetings. But the board was tough about it, and the town, when dealing with government agencies, they are not likely without a court order to pay you any money or to admit a mistake. So luckily for us, the town's insurance company got involved, and like Rich said, is shouldering, refunding most of the money because the investor relied on the town's information, which was wrong. So both of us were against the town to a degree, you know, saying, look, if you had kept your records right and you knew full well there were 7 years at which point no one paid a bill, and you knew we were meeting on other issues knowing that the developer was no longer around for the last 3 years, why would you continue to send them bills? So we're hopefully resolving that case. But there was another one where someone bought not even the clubhouse, it was a drainage pond. On part of the HOA, there are 8 or 9 drainage pond areas, and they're, you know, half an acre each. Someone purchased one of those lots because, again, the township had screwed up and made that not part of the common areas, but its own unit or its own piece of land with a lot and block number, and put it up for sheriff's sale, and someone bought it. So those things like that happen. Not all the time, but again, I think we want you guys to take away from today is that wacky things do happen. We've dealt with a lot of them between management and your attorneys. You can usually sort these things out, and don't be afraid to come to us and say, you know, look, there's some wacky stuff going on. We've seen a lot of it. Questions, concerns?
You just have to let us all know tomorrow how the mediation.
I will. I'll everybody send me an email, and I'll group respond to it. I have my fingers crossed. I think we're going to do good. And the association shouldn't pay any money, hopefully. We're just going to get our clubhouse back.
I don't know, we have horror stories like the landlord rents a unit, and we do have a small fee. We charge them $250 every time they rent, and they have to do it, I think, $300 to move their furniture in and out in case there's any damages, but ours is minuscule. The point is, they rent it, and then all of a sudden, there's 12 people, entire families living in there, and we've gone to the township, we've gone to the sheriff, and we're being told there's nothing you can do. Like somebody's running a nursery school out of one of the apartments, and they tell us there's nothing we can do. We don't have any. We get the paperwork, we get the C of O, the landlord registration, the certificate of occupancy, but who they put in and what they do after they're in there, what do we do?
So I'm going to ask a question. Are there any municipal zoning officials here in the room?
Please.
Anybody that works for your municipality? Good.
Please head to the back. Thank you.
Your municipality will do nothing to help you. That's the realistic thing to decide. They're not going to help you. They're not going to enforce their restrictions. They're likely not going to. What you need to do as an association, you need to get your attorney involved. You need to file an action against the owner to take those steps. In addition, in that lease rider, in addition to the ability to collect the rent, there should also be something in that lease rider that the association assumes power of attorney and has the right to evict people if the landlord is not evicting people on their own or not doing the right thing with the unit. So those are the things you want to make sure you have in that lease rider, so you can file a landlord-tenant claim and start working with your council to evict people from the units.
So is that the right to evict rider, is that something that we would get from our attorney?
Yeah. Yeah, you should get that from your attorney. It goes,
Online?
not like, you know.
Not a good one.
Everybody needs to know, I think, that the key to hiring lawyers is not necessarily that we always have the right answer, but you're relying on our answer.
Yep.
And if you rely on our answer in good faith, it protects the board, regardless of whether or not we're right. Because, you know, as much as we think we know everything, we're sometimes wrong. But it protects you guys when you rely on professionals, engineers, architects, accountants, and lawyers. It protects you as board members that you went to a professional, they gave you an answer, and you followed that advice. That protects you guys personally.
Okay, but that lease rider, to be able to evict, does that have to go in a resolution or go into?
It's generally a resolution. There might be language similar to what you're looking for already in your bylaw or in your master deed.
Okay.
But, I mean, if you have an attorney that practices in New Jersey in real estate or in condominium or HOA, they should be familiar with a lease rider along those terms. Looking at all the different options that boards have, we're not going to have time to cover my story, but the conclusion of my story was essentially the story was about a property management company that manages 52 associations, and it's been about 8 months ago, somebody within the company contacted me and said, Rich, you need to start looking at their financial records. And I'm like, well, which one? And they're like, all of them. Now, I represented about 12 of these associations. And I just called the board members up and I said, can you send me your financial records and your bank transactions? And they wouldn't tell me, this individual who I'm going to call Deep Throat, wouldn't tell me what I was looking for, but they said, just look for it. So I sat there, and I saw something, I saw a couple weird fees on there, I didn't notice anything, but I took 2 of them, and I took 3 of them, and I was putting all their bank records next to each other, and I started noticing the same fees on the same dates across all the associations. And what was going on is the management company was stealing money from the associations, but small, little amounts here and there, but they were doing them on the same dates across the board. And we saw that, and it's turned in now the DA. This is in Pennsylvania, so we've got the DA's office, we've got the AG's office going on here. We filed suit. I got about $1.2 million judgment against the management company and the owner of the management company jointly, severally, so they're both on the hook for this. If you look up his Instagram account, it says Billionaires Boys Club. You know, he's a hashtag with showing his new car and things like that. I mean, it was just like...
It's a lot of $50 charges to get there.
Well, and the charges probably fell right in line with their payroll period.
That's exactly what it was. It was like we would look back and we would see, well, wait a second, why did he all of a sudden need $600? And I would check, and I'm like, oh, guess what? He went to Italy that month, and he took 10 associations. He took $600, covered his trip, things like that. So, but how he was able to get away with that for the amount of time he was able to get was that the board members were trusting individuals and relied on the information that they were getting back from their management company. They were getting financial statements that were not the bank records. They were getting a document that the management company put together for them that said there was so much money in your bank account. And what he was doing is he had taken a significant amount of money, but he would take money from another association, deposit it into your account, and then therefore he could prove to you, if you asked on that date, what your account said. And so it was the right amount, but then you would just immediately take it back out and put it back where it needed to go, and was able to do that. And he'd been doing it, cycling this money around for a period of time here. It was pretty significant. But I just sat there and I was like, how? I would never have known. If somebody hadn't told me and called me up and told me, I wouldn't have seen it. The board members themselves, and I asked them, I said, well, how did this pass? He would change bank accounts without approval, things like that. So if you're on the board, if you're thinking about running for the board, just really don't be diligent. Don't trust it. Look at the invoices that you're getting. Unfortunately, if it's not a mistake, there are unscrupulous people out there that are in any industry, but in this industry too, that will take advantage with the assumption that they'll never get caught or you'll never look deep enough. So. But we've got, I just got the 5-minute signal, but if we got any further questions, yes.
I live in Ocean County. That's where Lakewood is. We have some unique problems. You're familiar with it. Our association passed a resolution. It was like, they're mentioned. It said if you bought a unit, you had to live in it 2 years before you could buy a second. maximum they can own is 2. That was done through a resolution of policy. None of the governing documents were changed. I also have friends that live in other communities, because there's a lot of retirement communities, and they pass similar resolutions. So I just want to double check. You said, if I understood you correctly, that you have to change your governing documents in order to do that.
Yes, it's my opinion that if you're going to try to restrict the ability to sell or buy a property, it needs to be through your declaration, an amendment through your declaration or your bylaws, declaration or your master deed. And the reason is that restriction on property, and this goes back to old-timey law school, old-timey property right, it needs to be in the chain of title, that restriction, and you get into like rules against perpetuity and rules against, limiting alienation of your property. That is, if I say to you, you cannot sell your property, I have significantly limited the value of your property. And you should have known that before you purchased it, or at least had a say in it. A resolution is passed by the board, you got a 7-member, a 5-member board, and all of a sudden they're like, you can't buy a second property. That may have just killed the value of a significant number of homes in the community.
I think generally the court looks.
The trivia is that we grandfather those
That's
Sure.
what we're doing.
Sure.
So we had
That'll prevent a lot of problems.
property.
Right.
That was grandfathered over.
Sure.
Anybody new couldn't do it.
The court will look much more favorably on a master deed amendment than it will a resolution when it comes to those sort of things. So if you got everyone to vote, the condominium associations are essentially a contractual obligation. You guys all agree to operate under certain rules. And if all of the unit owners, or how many, like Rich said, 67%, agree to amend the master deed to effectuate some change, the court's going to look much more favorably on that than it will the board simply passing a rule or regulation or then a resolution. There's definitely a hierarchy of things that you can
Isn't
do.
that just changing now where you only need a certain form? You don't have to do that
That's
67.
for bylaws.
With the
It
bylaws.
takes for bylaw
bylaws.
amendments, yeah.
Right.
Now it's like a negative. You can switch it so that you can send it out, and if 10% of the people object.
But only for bylaws. Remember, your bylaws cover more of your governance, your board, the number of seats, when your elections happen. Your master deed really controls how the property operates. So you cannot get a negative vote for master deed amendments. You still have to get a supermajority for the most case, which is 66 2/3 of the community to agree. And if you're at a 40% rental occupancy, you're not going to get investors to vote for something that stops them from being able to rent their units.
And as a really...
Applicable to co-ops also?
It depends. I believe that co-ops can actually amend their documents without a supermajority, depending on what it is. But certain aspects of the Radbourne Act cover co-ops as well. But again, you should speak with your attorney about that.
Yeah. Real quick, this is the backroom advice. A lot of times attorneys will give you advice. For example, pass a resolution. Not that the resolution is going to be enforceable in court ultimately. It's like these non-disclosure agreements you've been hearing in the news a lot. A lot of these documents ultimately will not be enforceable, but the terms of them and the idea that you will fight over them may scare people away. So if I say, pass a resolution that says you can only buy 2 homes and you can have to live here for 2 years, ultimately, if somebody really wants to buy in your community and they want to hire a lawyer and they want to go to court, they might win. But they may not want to spend $30,000 in legal fees to prove that they're going to win that case.
That's a good point, too. Like, our associations often call us and say, can we pass a resolution that says X? And our response is usually, are you willing to go to court to enforce X? If the answer is yes, then most often you should pass that resolution, unless there's some other extenuating circumstance. But association could pass lots of rules. The key is you need to be able to enforce them, and you need to be behind them, spend legal fees and spend costs and time and show up to depositions and all the other nonsense that goes along with them. So passing a rule is not just passing a rule and you assume it's going to be followed. You have to assume that people are going to violate it, and when they do, you need to be prepared to enforce them.
That's our time. I thank everybody. I thank our panelists.
Thank you.
With that, have a great afternoon.
Thanks, guys.
Good job. First time. Come on.